Welcome everyone! Hello Philippines and hello world! This is Michelle Rose Abellana.
I am Cassandra Layson.
And I am Michelle Catayas.
And we are your
International
Lady Juris.
And of course, before we start, we welcome our 13,500 followers on YouTube and Facebook. To all of the students and viewers out there, you're free to send us your comments and questions regarding with our topic for today. Alright!
Yes, and today we are going to discuss a very interesting topic relating to public international law. This case was entitled North Sea Continental Shelf, or like the Federal Republic of Germany versus Denmark. It was promulgated in 1969. So this is a case which involves the delimitation of the continental shelf areas in the North Sea between Germany and Denmark and Germany and Netherlands, beyond the partial boundaries previously agreed upon by the states.
And the parties requested the court to decide the principles and rules of international law that are applicable to said delimitation because the parties disagreed on the applicable principles or rules of delimitation. Now, Netherlands and Denmark relied on the principle of equidistance. It is the method of determining the boundaries in such a way that every point of the boundary is equidistant from the nearest point of the baseline from which the breadth of the territorial sea of each state is measured. Now, Germany sought to get a decision in favor of the notion that the limitation of the relevant continental shelf was governed by the principle that each coastal state is entitled to a just and equitable share, or called as the just and equitable principle or method. Now, contrary to Denmark and Netherlands, Germany argued that the principle of equidistance was neither a mandatory rule in the limitation of the continental shelf nor a rule of customary international law that was binding on Germany. The court was not asked to delimit because the parties had already agreed to delimit the continental shelf as between their countries by agreement after the termination of the court on the applicable principles.
Now, as to the facts of this case, the Netherlands and Denmark had drawn the partial boundary lines based on the equidistance principle, which is A, B, C, and D. While on the other hand, Denmark and Netherlands wanted to use the equidistance principle, which is B, E, D, and E. Well, together, if these two boundaries would produce an inequitable result, such as Germany stated that due to its concave coastline, such line would result in her losing out on her share of the continental shelf based on the proportion of the length of its North Sea coastline. So the court had to decide whether the international law applicable to this delimitation. And in doing so, the court had to decide if the principles espoused by the parties were binding on them, either through treaty or the customary international law.
Okay, so grabe pala yung pinaghuhugutan ng case na ito, no? So there is this question here. Is Germany under a legal obligation to accept equidistance special circumstances principle contained in Article 6 of the Geneva Convention of the Continental Shelf of 1958, either as a customary international law rule or on the basis of the Geneva Convention?
The use of the equidistance method had not crystallized into customary law, and the method was not obligatory for the delimitation of areas in the North Sea related to the present proceedings.
How about the nature of the treaty obligation? Is the 1958 Geneva Convention, and in particular Article 6, binding on Germany?
Well, Article 6 of the Geneva Convention stated that unless the parties had already agreed on a method for, then the equidistance method would apply. And Germany had signed but not ratified the Geneva Convention. So while Netherlands and Denmark were parties to the convention, the latter two states argued that while Germany is not a party to the convention, she was still bound by the Article 6 on the convention. Why? because, as stated in the Geneva Convention, Article 6, by conduct, by public statements and proclamations, and in other ways, the Republic has unilaterally assumed the obligation of the Convention or has manifested its acceptance of the conventional regime or has recognized it as being generally applicable to the delimitation of the continental shelf areas. And on Section 2 of Article 6 stated that the Federal Republic had held itself out as so assuming, accepting, or recognizing in such a manner as to cause other states, and in particular Denmark and Netherlands, to rely on the attitude thus taken up, the latter called the principle of estoppel.
But the court rejected the first argument. It said that only a very definite and very consistent course of conduct on the part of the state would allow the court to presume that the state had somehow become bound by a treaty when the state was at all times fully able and entitled to accept the treaty commitments in a formal manner. Now, the court held that Germany had not unilaterally assumed obligations under the convention. The court also took notice of the fact that even if Germany ratified the treaty, she had the option of entering into reservation on Article 6, following which that particular article would no longer be applicable to Germany. In other words, even if one were to assume that Germany had intended to become a party to the convention, it does not presuppose that it would have also undertaken those obligations contained in the Article 6.
And let us note din the Vienna Convention of the Law of Treaties of 1969, or the VCLT, which came into force in 1980. It discusses in more detail treaty obligations of third states. So these are states who are not parties to the treaty. It clearly stipulates that obligations arise from third states from a provision of a treaty only if 1. The actual parties to the treaty intended the provision to create obligations for third states, and 2. Third state expressly accepted those obligations in writing. So this is Article 35 of the VCLT. So the VCLT was not in force when the court deliberated on this case. However, as seen above, the court's position is consistent, the VCLT.
Okay, so the court held that the existence of a situation of estoppel would have allowed the Article 6 to become binding on Germany, but held that Germany's action did not support an argument for estoppel. The court also held that the mere fact that the Germany may not have specifically objected to the equidistance principle as contained in Article 6, it is not sufficient to state that the principle is now binding upon it.
And in conclusion to that, the court held that Germany had not acted in any manner so as to incur obligations contained in the Article 6 of the Geneva Convention. The equidistance special circumstances rule was not binding with Germany by way of treaty laws.
Alright, so Lady Juris, there is a question from one of our top fans, si Mr. Cardo Dalisay. He said, as to the nature of the customary international obligation, is Germany bound by the provisions of Article 6 of the Geneva Convention insofar as they reflect customary international law?
Well, that's a good question. To answer your question, Mr. Cardo Dalisay, Netherlands and Denmark argued that Article 6 also reflected the accepted rule of the general international law on the subject of continental shelf delimitation, and that it existed independently of the convention. So therefore, they agreed Germany is bound by the subject matter of Article 6 by way of customary international law.
And to decide if the equidistance principle bound Germany by way of customary international law, the court examined first the status of the principle contained in the Article 6 as it stood when the convention was being drawn up, and second, its status after the convention came into force.
Okay, thank you so much for participating with us, Mr. Cardo Dalisay. You will now receive your International Lady Juris badge. Congratulations!
Wow, here is another question from our top fans named Mr. Joseph Asong. And here is his question. What was the customary law status of Article 6 at the time of drafting the convention?
Yes, and to give you insights, Mr. Asong, the court held that principle of equidistance as contained in Article 6 did not form a part of existing or emerging customary international law at the time of drafting of the convention. The court supported this finding based on, first, the hesitation expressed by the drafters of the convention, the International Law Commission, on the inclusion of Article 6 into the convention, and second, the fact that reservations to Article 6 was permissible under the convention.
And to add up, Article 6 is one of those in respect of which, under the reservations article of the convention, or like the Article 12, reservations may be made by any state on signing, ratifying, or acceding. For speaking generally, it is a characteristic of purely conventional rules and obligations that, in regard to them, some faculty of making unilateral reservations may, within certain limits, be admitted, whereas this cannot be so in the case of general or customary law rules and obligations, which by their very nature must have equal force. All members of the international community and cannot therefore be the subject of any right of unilateral exclusion, exercisable rather at will by any one of them in its own favor. So the normal inference would therefore be that any articles do not figure among those excluded from the faculty of reservation under Article 12 were not regarded as declaratory of previously existing or emergent rules of law. So you can see this paragraph 65 for a counter-argument and the court's careful differentiation.
Alright, thank you so much for participating, Mr. Asong. You will also receive an International Lady Juris badge. Congratulations! And now, here's another question from Miss Lily Argente. Did the provisions in Article 6 on the equidistance principle attain the customary law status after the convention came into force?
Thank you, Miss Argenta. The court then examined whether the rule contained in Article 6 had become customary international law after the convention entered into force. And the court held that Article 6 of the convention had not attained a customary law status.
And for a customary rule to emerge, the court held that it needed very widespread and representative participation in the convention, including states whose interests were specifically or specially affected. In this case, there were coastal states or the generality and virtually uniform practice, or like the consistent and uniform usage undertaken in a manner that demonstrates general recognition of the rule of law or legal obligation, or the opinio juris. So in the North Sea Continental Shelf cases, the court held that the passage of the considerable period of time was unnecessary for the formation of a customary law.
Alright, thank you so much guys for your active participation. Rest assured that your International Lady Juris badge will be delivered at your home. Congratulations! And now, to give you some insights on the widespread and representative participation, the court held that the first criteria was not met. The number of ratifications and accessions to the convention for the 39 states were not adequately representative or widespread.
And also, to add up insights of this duration, the court held that although the passage is only a short period of time, it is not necessarily a bar to the formation of a new rule of the customary international law. An important requirement would be within the period in question. Now, states whose interests are specifically affected should have been both extensive and virtually uniform in the sense of the provision invoked, and should moreover have occurred in such a way to show a general recognition to the rule of law.
And lastly, the court concluded that the equidistance principle was not binding on Germany by way of treaty or customary international law. In the case of the latter, the principle had not attained a customary international law status at the time of the entry into force of the Geneva Convention or thereafter. As such, the court held that the use of the equidistance method is not obligatory for the delimitation of the areas concerned in the present proceedings.
So to wrap things up, the jurisprudence on the North Sea continental shelf cases sets out the dual requirement for the formation of customary international law. First is the state practice or the objective element, and second is the opinio juris or the subjective element. The court explained the criteria necessary to establish state practice or widespread and representative participation. It highlighted that the practices of those states whose interests were specially affected by the custom were especially relevant in the formation of customary international law. It also held that uniform and consistent practice was necessary to demonstrate opinio juris. Opinio juris is the belief that state practice amounts to a legal obligation. The North Sea continental shelf cases also dispelled the myth that duration of the practice, or example, the number of years, was an essential factor in forming customary international law.
Thank you so much, guys, for joining with our international law topic today. For more info, feel free to send us your comment below, and don't forget to subscribe to our channel, International Lady Juris.PH.
What a wonderful learning session!
See you again for the next episode.
Bye!